Good morning, everyone. I'm your host, Mary Lou Burnsick, and thank you for joining us at our May meeting of the Arizona Mental Health Criminal Justice Coalition. I'm the director of David's Hope. For those of you that are new to our meetings, David's Hope is the nonprofit organization that holds the program of the Arizona Mental Health Criminal Justice Coalition. And that we lead, and that is operating and working in our state to reduce the numbers of people with mental illness that are incarcerated. And you are the important part of that coalition. You, the members that keep us up, going, and working every day to bring all of our mental health criminal justice stakeholders together. I'm delighted today that we're going to be having, that Anna Mendez is going to be joining us, and she's here already with us. Hello, good morning, Anna. Thank you for being here.
Good morning.
All the way from Virginia. So that is, those of you that have been able to take a look at Anna's bio, I'm sure you've been impressed, and I'll be sharing that with you a little bit later before Anna begins her part speaking. I'm going to talk a little bit about the notice that I sent out earlier this week, because we want to make sure that we're including a broad group of stakeholders in our report outs that we do. And we have a great group that's regularly with us and has been for years. You know who you are. Our law enforcement partners, our folks from probation, our county criminal justice coordinating coordinators, and behavioral health folks, the OIFA leads, and our folks from Access and Nami. We thank you all for the many years that you've been available for us. I mean, pretty much, I know it's been a part of your life that the first 30 minutes of our coalition meeting, be ready to for me to call your name. And I was thinking, gee, what that must feel like after so long and being a part of this. And I know that always you don't necessarily have an update to share every single month. So what the plan is to begin having you contact me when you have something that you'd like to share that's a part of the work that you're doing at any level, really, involved in the work of your efforts in your counties and your local regions and your cities to improve outcomes for people living with mental disorders and addictions that are involved in the justice system. So it's scary because I would love to have like 1,000 people talk every month, and of course we can't do that. But sometimes I think I'm sure that we're missing some important things that are going on around the state because we've been kind of pulling the wagon the same direction for so long. So I thought shaking things up a little bit could be a good booster to give us a little bit of a new direction, and hopefully reach into some of the regions that we have not had really been able to make a good connection with folks in some of our more rural counties. So I hope that makes sense. Feel free to contact me at any time to discuss this. Thank you, Melissa. Melissa's giving us a good comment, and I have heard from a couple of you already that you're feeling okay about this. So I do appreciate your input always. Our coalition is always looking to see the work of the Stepping Up initiative, basically, and how it has progressed around the state. All of our 15 counties have signed on. Our tribal regions are engaged, working to create more opportunities for diversion for people with mental illness, addictions, and other mental disorders. But if we don't know about it and people aren't sharing, it's really a missed opportunity, because so often what one county's doing can be used to build on in another county. So again, I just invite you to, some of the, you all know the rural counties that, we have good engagement with and some we don't, but I'm going to be asking for help to try to create a better lifeline to some of those areas where we, for instance, if I was to say, who knows what's happening in Stepping Up or in mental health, criminal justice stakeholder coordinated work in a county, and say I name a county, who comes to mind? I mean, do you that have been coming to our coalition and participating with us now for many years, you probably know as much as I do about that. Some of you know a lot more. But do you know someone in every county that you could point to that you would say is a coordinator of that work, that's a champion, that's, if not formally engaged in that work through an appointment by the county? Sometimes we have people that are even behind the scenes that know everything that's going on. So that's why when I sent the notice out this week, I mentioned Stepping Up coordinators, and I said that definition can be flexible. So if we have if we have a county that doesn't have a formal criminal justice mental health committee, that's okay. But who do we have in the county that can work with us at the coalition to just check in maybe a couple times a year to give us updates of what they're seeing, how they're seeing this work progress in their region, and if they're feeling connected to the statewide effort. So we've got leadership in many areas, and we're far. I do feel we're far along the path, headed the right direction. We're definitely headed the right direction, and I think we're standing on very solid ground right now. So that's just a little bit of an explanation of why we decided to make this change, and I'm asking for your input. If you don't like it, think it's a bad idea, let me know, or have an idea how you think better that we could utilize the first part of the meeting. But basically, we're looking for regional output or input from every county, and I'd like to have more of our tribal regions participating as well. So if you have connections where we don't have any, please help hook us up. And with that, I'm going to go ahead and mention, that we're recording this meeting, that we've begun to put our meetings on YouTube. So that's been met with a lot of positive feedback. So just keep that in mind. We're going to be later on asking for you to go ahead and ask questions if you'd like, or you can make comments related to the presentation that Anna's going to be doing. I'm going to ask that you do that through the chat rather than verbally, just because we don't want to have conflicts on the line and on the audio. But we will be going through the chat, and we will present those comments and questions to Anna. So I'm going to now go ahead and call on a couple of folks that I did speak with earlier, or communicated with through email about if they'd like to share this morning. And one of them is Detective Sabrina Taylor from Phoenix PD. And I know, Detective Taylor, you have you have good things going on, and we'd like to hear about them. So go ahead.
Okay. Well, mostly it concerns the CIT International Conference that's coming up in about 3 months in August. I know if I forget something, I think Amanda and Frank are on the call. They can help me out. But Amanda's been doing a great job reaching out to sponsors and exhibitors. But if there's anybody on this call that's interested in sponsorship or having a booth at the conference, feel free to reach out. They usually don't charge for like peer member organizations. So I know Nami National is going to have a table. They're not traveling this year. So Jim Dunn, and Jim might be on the call too, is going to run that booth. And then Nami is providing 65 scholarships. And I know they just put that out there. So if anybody wants to try to get their registration covered by Nami National, they could still put in for that. And then we are going to need a bunch of volunteers, and Jessica Westmiller has been kind enough to help us work all that. So if you're interested in volunteering, you could reach out to me, Frank, Jessica, and we're kind of keeping a master list. And as we get closer, we'll start trying to figure out who wants to work what shift. And so that's the big conference news for us. It's kind of absorbing all of our time.
Thank you, Sabrina. And we made some nominations. I know I did. Is that secret, or are we allowed to talk about that?
Oh, we could talk about it. I heard from the chair for the awards committee. They got 85 nominations, but there's like a bunch of categories. And so normally I would be scoring them with you, but I made a bunch of nominations too. So I'm out of the loop for that.
Okay, well, we made some nominations of some Arizona leaders, and it's okay to say who I nominated?
Oh yeah, go for it.
So I don't want to like do anything that CIT is going to be mad about. Of course, I have no idea who they're going to choose, but I nominated Sheriff David Rhodes from Yavapai County because of his tremendous leadership that he's done. Not just in CIT. I know the CIT International wants to know about the CIT work, but we threw a lot of other things in there as well. The transparency and the way they've coordinated with other counties, the way they worked on legislative work, and just all the way around the board. So wouldn't it be amazing if one of our own was honored as the law enforcement executive, it was called, right? The executive award. Yeah. So
thank you for doing that. We struggle to get good nominations in that category. And since CIT International is here, I thought we should nominate our folks because I thought they had a good chance.
Absolutely. So our law enforcement is tremendous, and we just can't say enough about him, and we need to keep nominating year after year. So there's a lot of you here on this call that need to be nominated as well. So hopefully we'll see you all awarded before the coming years. All right. Well, thank you, Sabrina. And Don Wilson from Navajo County, are you on the call? Dawn is the criminal justice coordinator from Navajo County, and she was planning on being here. I'm not seeing Dawn. So we will, yes, Ralph, hi. Ralph Engler from Nami White Mountains, which is the Navajo region.
I had lunch with Dawn here about a week or so ago. She is one busy lady, I will tell you. but we had a good lunch and talked about her work and our work in criminal justice here in the Northeast part, along with our jail coordinator over there in Apache County, Michael. But good stuff. I'm impressed with her.
Yes, she was planning to be here, so she must have gone. I know she travels a lot on the road, so yeah.
She's just very, very busy.
Right. Okay, thank you, Ralph. Thank you for what you do up there in the White Mountains. And are there any, since I did a switch on everyone, I don't want to just call on folks, but are there any other law enforcement officers on the call that would like to provide an update or share anything from the work they're doing? Because I would invite you to jump in if you do. Okay. All right. Well, we are going to I'm gonna go ahead and do our poll. Let me go ahead and do our poll now, and before we get started with the rest of our meeting, I'm going to pull up our monthly poll that you all love so much. So here we go. Get ready to participate, and I'm going to go ahead and get that poll started now. So you should be seeing that. First question, my relationship to a person living with a mental illness and or addiction is as a peer or family member, as a professional, as both a peer and or family member and a professional. Question number 2, the county I live in has leadership who are actively engaged in creating better outcomes for individuals with mental disorders and addictions who become justice involved. Wow, you all are liking your counties today. We have the options are yes, no, and I am not sure. Everybody's feeling good about their counties today. I'm seeing a large percentage of yeses there. And our third question, I believe Arizona law provides adequate protection for individuals living with mental disorders who become justice involved. And we see responses there. So I'm gonna, looks like your responses have come in, and the answers for that last question, yes, no, and I'm not sure. I apologize to folks on YouTube as you won't be able to see this, but I'm gonna be reading you the results, and I'm gonna right now share the results with you. For question number 1, relationship to a person living with a mental illness or addiction is 14% are peer or family members, 23% professionals, and 64% are both peer and family member and a professional. That's amazing. The county I live in has leadership who are actively engaged in creating better outcomes for individuals with mental disorders and addictions who become justice involved. We've got you responding at 86% today that yes, your county is engaged. Now that is that's an improvement from what we've been seeing. So either counties are doing better, or most of our folks today are from the same county that's doing really well. So we'll have to study that one. And I believe Arizona law provides adequate protection for individuals living with mental disorders who become justice involved. And I thought this question would be appropriate with our presenter, Anna Mendez, today with us. So we have a lowly number of 5% saying yes, that they think we have adequate protection. So you can see those 60%, 68% saying no, and 27% I am not sure. So thank you for that. I'm going to turn the stop sharing the results there. And get back out of that screen. All right, so do we have I know we have I think I know Sherry from Nami is here. Sherry, do you have any updates? I don't think Jim's on the line, is he? would you like to share anything from Nami, Sherry Candelaria?
Yes.
Sure, go ahead, Sherry.
I don't know if Jim's on either, but as Sabrina mentioned, obviously we're very busy because we will be manning the NAMI national booth at the CIT conference, and we're bringing in all of our affiliates. So it's gonna, I think, be a great, get together there. Tonight, just so everybody knows, we're rolling out our first NAMI Homefront class, and we're doing it, we're doing it down here, sort of focusing in the Maricopa County area. But anybody who is interested in attending is welcome to do so. Just let me know. It starts at 6 and goes till 8. It's, of course, virtual. And NAMI Homefront is for family members and caregivers, friends, anyone who is related or working with veterans. So it's pretty wide open there. And the other thing I would say is all the affiliates are hopping with rolling, different education sessions out there. And some of them have gone back to face-to-face. So that's a really good thing. That's it.
And good morning, Jim is
there
here.
he is.
And Mary Lou, I just want to thank you once again. This platform in our relationship these 15, 20 years has really provided an incredible foundation for this chance to celebrate the CIT collaboration we have statewide with law enforcement, and Sabrina and Amanda and, all these wonderful people that you brought together who traditionally don't work well together. So it's a privilege to walk with you guys, and I'm excited to share those great relationships with the world. So Sabrina, guys, anything we can do to help you be successful, let us know. But we're going to bring as many of our troops in as we can.
That's awesome. Thanks, Jim.
Thank you, Jim. And appreciate so much our partnership with NAMI Arizona and also OIFA Access. For those of you that, for Anna, who's not from Arizona, Access is our Medicaid system. So they have, they're just super with including peer and family members in the planning and systems planning, and the work of Jim Dunn and his leadership has really been hugely responsible for making that happen. So we appreciate so much our partnership with both OIFA Access and with Access and through the OIFA office, and Jim Dunn, his leadership at NAMI Arizona. And do we have, I did not check with OIFA, Jamie or Susan. I don't think they're here today. But I usually have them share, but I don't think we have them. So, gee, I feel kind of sad not calling on all of our people I usually call on, but I'm committed to change the way we do things. So here we go. We are going to, and we managed to all the way get almost 10:30. So I don't know how we normally get so many people in that time frame. But I'm going to go ahead now, and very excited to introduce our guest presenter. I just about jumped out of my chair when I read about her. Anna is in Virginia, and I'm going to read a bit of her bio because I think it's important, and I did send that out to you, and you can look over that again to get more in-depth information. But Anna Mendez is the executive director of Partner for Mental Health in Charlottesville, Virginia, and Anna had explained to me that that is the local chapter of Mental Health America there. And she is also board president of Mental Health America of Virginia. Partners for Mental Health believes decriminalizing the experience of mental illness is an essential component of criminal justice reform. She is a fellow in residence at the University of Virginia Equity Center, where her research focuses on the decriminalization of mental illness. She serves on the board of the Charlottesville Therapeutic Docket, a jail diversion program for defendants with mental illness. And she was recently appointed to Virginia's Marcus Alert implementation team, a group charged with developing a statewide non-police response system for 911 calls related to behavioral health crisis. So Anna is a busy person, and yet I didn't ask Anna to go into how you connected with Pete early, but he found you obviously because of the work you're doing, and I was so glad he did, and did the write-up that I shared with our coalition related to your work in criminal defense of people with mental illness. So thank you, Anna, for being here, and I'm going to go ahead and turn it over to you now. And don't forget, folks, you can put questions and comments in the chat, and we will get to you after Anna's presentation is ended.
Mary Lou, thank you. Thank you so much for that introduction. I have to admit that Pete early did not find us. We found him. We made a bit of a splash almost a year ago when we sent a letter to our city council here in Charlottesville, Virginia, giving them a list of action items that we could implement locally around the decriminalization of mental illness. And I sent it to Pete somewhat on a lark, and he really liked it. And that was the first time he published something that we had written, and we've since stayed in touch. And so that is how he learned about the work that I'm going to talk to you guys about today. HB 1315/HB 2047. So the first thing I'm going to attempt to do with this lovely technology we have is I'm going to attempt to share my screen. So bear with me in just a moment. All right. Mary Lou, can you give me the thumbs up if you can hear me and see my screen?
I can, but we need to enlarge the screen a bit.
Yeah, hang on just a second.
But yes, I'm hearing you perfectly, seeing your video, and I can see the PowerPoint.
All right, there. Is that enlarged?
There we go, yes.
All right, wonderful. Okay. So as Mary Lou said, I am the executive director of a nonprofit in Charlottesville called Partner for Mental Health. And I am going to talk to you. I'm going to actually, before I talk anymore, I'm setting the timer on my phone as a kind of a way to hold me accountable for not going over time. I'm going to talk to you guys today about the work that we had the privilege to do in Virginia's most recent General Assembly session, allowing defendants to present evidence relating to their mental condition at trial. Kind of the subtitle for this presentation is Burning Stamper to the Ground. And I'll tell you a little bit more about who Stamper was and why we were so happy to see him go up in flames. So just going to start by telling you a little bit more about who we are. Partner for Mental Health, as Mary Lou said, we are the Charlottesville area affiliate of Mental Health America of Virginia. We provide both direct service and advocacy related to mental health issues in the Charlottesville, Virginia area. Our affiliate has been in existence since 1947. So we're pushing like 75 years. And we have always worked to create a community that is best able to support its members living with mental illness. Historically, this looked very different than what we do today. Initially, the work of our affiliate was really around improving conditions in our state hospital system, because for far too long, being diagnosed with a serious mental illness meant that you weren't going to live in the community. In Virginia, you were going to be sent to one of our 7 state psychiatric hospitals. In 1981, the year I was born, our affiliate actually staged a sit-in protest on the steps of Western State Hospital in Stanton, Virginia. And this demonstration, along with its media coverage in national media, the Washington Post, was really credited with modernizing Virginia's state psychiatric hospital system. And we are very proud of that history. But as times have changed, we have changed. And now we really are working to facilitate people living with mental illness in their home communities. We do this by providing advocacy for practice and policy change at both the local, regional, and state level. And that's going to be the heart of what I talk to you guys about today. We also provide community education around issues pertaining to mental illness and mental health and wellness. And we provide direct service to individuals living with mental illness. And I'm going to take a minute to tell you about this direct service, because it is this direct service that led us to the work that I'm going to talk to you about today. So we provide a service to community members that we call systems navigation. And what this is we help people living with mental illness access the clinical care that they want. And we also help them address and improve their social determinants of health. So, and our team members that do this work, we call them navigators. And so our navigators will meet with a potential client and ask them, what are your goals for your life? And how can we help you? And we work with about 200 people a year. And about half of the people we have the privilege of working with tell us that they're struggling to access some type of clinical care, therapy, psychiatry, something along that lines. And we help them address the gaps or the barriers that are preventing them from getting the clinical care that they need. Half of the people we work with never mention their mental illness to us. And instead they say things like, I need help getting stable housing. I need help finding a job. I need help completing my GED or getting my associate's degree. I need help mending relationships with my family. So these are all things that are called social determinants of health. And we know that someone's long-term health outcomes are actually more influenced by their social determinants of health than by their access to clinical care. And that's why we work just as hard helping people improve their social determinants of health as we do helping them find a therapist or a psychiatrist. We've been running this navigation program in Charlottesville for the last 5 years, 5.5 years since I became executive director 5.5 years ago. And over the course of that 5.5 years, we have been so successful, or this programming, this approach, not just connecting people to mental health services, but also helping them address their social determinants of health, has been so successful in our community that we have come to the attention of our local criminal justice system. So there's a reason. I'm looping back to the reason why I'm telling you guys all of this. And in particular, we are fortunate in Charlottesville and the surrounding county of Albemarle to have very progressive prosecutors who want to have a solution for defendants with mental illness that is not you go to jail. And so we have had the privilege of working with defendants with mental illness and their defense attorneys and the Commonwealth to come up with alternatives to incarceration for them. And it has been through this work, I am not an attorney yet, but it is through this work that we became aware of the fact that in Virginia, defendants with mental illness are prohibited from introducing evidence related to their mental illness during trial. And that is a very important thing that I'm going to bracket for just a minute, and we'll come back to. So to give you guys a bit of an overview of the landscape of how the intersection of mental illness and the criminal justice system in Virginia, it's important for you to know that in Virginia, we do have crisis intervention teams in some localities, not in every locality. And even in the localities in which we have crisis intervention teams, there is not a single locality where all sworn officers are crisis intervention trained. So that's an important thing to keep in mind. We also have about a dozen what we call in Virginia therapeutic dockets. I think in most places they're often called mental health courts. We have to do things differently in Virginia, so we call them therapeutic dockets. These are jail diversion programs. They do not divert people from the criminal justice system, but if successful, they do divert people from jail. So these therapeutic dockets exist in 12 jurisdictions across Virginia. 11 of the 12 only adjudicate misdemeanor crimes. There is one felony therapeutic docket in Virginia. So essentially, only in 12 jurisdictions, and only one that you can actually hear a felony on. And half of these therapeutic dockets are structured in a way that is called post-plea. And what that means is that before a defendant can enter into the therapeutic docket, they must plead guilty. And of course, for the attorneys on this call, you know that means they also, in so doing, they are giving up their constitutional rights with no guarantee that they're going to have a good outcome. So we're grateful that therapeutic dockets exist. I serve on the advisory committee of the Charlottesville-Albemarle therapeutic docket, and I'm proud of the work that we're doing, but they are not the solution for everyone. We also in Virginia have what is called not guilty by reason of insanity. So this is an adjudicative outcome. It is an acquittal. It is in Virginia. It is a full acquittal, where the person must show either that they did not understand, because of mental disease or defect, did not understand the nature of their actions, or could not differentiate right from wrong, or had an irresistible impulse. So we do have an adjudicative finding of not guilty by reason of insanity. The result of an NGRI finding is that a person will be civilly committed to one of our state psychiatric hospitals for an indeterminate period of time that generally far exceeds the maximum sentence they would have served had they been found guilty. That is a very strong deterrent for convincing a defendant to consider an affirmative defense of NGRI. And as a result, less than 0.02%. So not 2% and not 0.2%, but 0.02% of all Virginia criminal defendants are ever found not guilty by reason of insanity. So that's the backdrop of mental illness in the criminal justice system in Virginia that I think is important context to have as I talk about what we did in this General Assembly session. And even though we have crisis intervention teams, and even though we have therapeutic dockets, and even though we have not guilty by reason of insanity, the data still shows that we have a really serious problem. And You're like, what data? What problem? So locally, so we are in Charlottesville, Virginia. There's a little university here called the University of Virginia that likes to think they're pretty special, and they are. And they have done some data analysis for us. And what they are able to tell us is that 30% of everyone in our regional jail screens as likely having a serious mental illness. So let me just say that again. 30% of everyone in our regional jail screens as likely having a serious mental illness. So not just a mental illness, but a mental illness serious enough to impact a significant domain of their life. So either their ability to keep employment, their ability to maintain social support, things of that nature. And research has also shown that locally, individuals with mental illness are treated more harshly at each point on the sequential intercept model than are people without serious mental illness. And so what this means is if you have two defendants, and this is when we've done some fancy regression analysis to show that this is true when you control for everything else. So essentially, if you have two defendants that are the same race, the same gender, they have the same criminal background, they've been assessed as having the same criminogenic risk structure, they're facing the same charge. If the only difference between these two individuals is one has serious mental illness and the other does not, that at each point on the sequential intercept model, the person with serious mental illness is going to be treated much more harshly than the control. So this means they're more likely to be arrested. This means if they're arrested, they're less likely to receive bond. We still have cash bail in Virginia. They are more likely to have a bond review denied. They are more likely to be found guilty. They are more likely to be sentenced to incarceration, and they are going to serve a longer sentence. So that is what the data shows. And all of those things are a problem. And together, all of those things are contributing to a pattern that we began to see at Partner for Mental Health. And we saw this pattern because we were providing our navigation service to individuals that had become involved in the criminal justice system. And what we were seeing was that even in progressive Charlottesville, and it's really, really hard if you're not familiar with Virginia and Charlottesville, it is really hard for me to adequately convey how progressive Charlottesville likes to at least claim to be. We will often be referred to as the People's Republic of Charlottesville, or the shining blue dot in the middle of a sea of red in Central Virginia. So even in that context of a very progressive community, what we were seeing at Partner for Mental Health through our work supporting clients in our navigation program was defendants with mental illness either being convicted of crimes that they did not have the intention to commit, or defendants taking unfavorable plea deals because they knew that they could not introduce evidence about their mental condition at the time of the alleged offense in trial. And the more we became aware of this, the more enraged, I guess you could say, we became. So that is, I told you we were going to come back to Stamper and who was Stamper and why did we want to burn Stamper to the ground? Excuse me. So the first thing that's important for a little bit of context, in the late 70s or early 80s, there was a defense attorney in far southwest Virginia by the name of Stamper. So Stamper is a defense attorney. And Mr. Stamper was very successful in defending notorious drug dealers. He was a very skilled attorney, and he was really good at getting people acquitted. And this brought him unfavorable attention from local law enforcement, who were really frustrated that they kept making pretty big drug busts only for Mr. Stamper to be able to get his clients acquitted. So the police eventually, on a tip, raided Mr. Stamper's personal residence. And what they found was many, many, many kilos of marijuana. Apparently what had been happening was, yes, he was really good at getting drug dealers acquitted, and these drug dealers liked to pay him in contraband. So needless to say, Mr. Stamper himself was arrested and convicted of possession and distribution. Mr. Stamper and his legal team appealed his conviction to the Virginia Supreme Court in 1985. And they appealed on numerous grounds. I mean, like half a dozen grounds. There is only one of those reasons is important for me to talk to you about. And that was, they said that his conviction should have been overturned because the trial judge would not allow Stamper to introduce evidence relating to his longstanding bipolar diagnosis into evidence. And this is what the Virginia Supreme Court said about that. And you guys can read this, but essentially what they said was the field of medicine changes so quickly that we have decided it is not reasonable to expect Virginia's court system to stay up to date on all of the advances in psychiatric medicine. Therefore, we are deciding that such evidence is by definition irrelevant unless the defendant is going to plead not guilty by reason of insanity. So this is since 1985, so 35 some odd, whatever, for the last 35 years, this Supreme Court ruling is the reason that no defendant in Virginia has been able to have their mental status at the time of the alleged offense acknowledged during trial, unless they are one of those 0.02% of defendants who are going to try to plead not guilty by reason of insanity. So this is kind of the background of where we were when Virginia's General Assembly came into session in January of this year. We do things kind of oddly in Virginia. Our General Assembly is only in session for either 45 or 60 days, depending on the year. So we were only in session in January and February of 2021. And you're looking right now at pictures of Virginia State Senator Jennifer McClellan. She's in the blue with the pretty necklace, and underneath her is Virginia House of Delegates Representative Jeff Bourne. And together this year, they introduced SB 1315 and HB 2047, I'm going to show you the actual language in just a moment, but what it did, its entire point was to nullify this Supreme Court ruling, because this Supreme Court ruling that you're seeing on the screen is the reason why defendants in Virginia could not introduce evidence related to their mental status at the time of the alleged offense. So why now? It's been 35 years. Why now? And there are really a couple reasons for this. One is in 2020, for the first time in my lifetime, the governor of Virginia and both houses of Virginia's General Assembly were led by Democrats. And I will acknowledge that both Senator McClellan and Delegate Bourne are Democrats, and they are both strongly committed to criminal justice reform. They were approached by the mother of a young man with autism, who was serving a 50-year sentence for a non-fatal car accident because he and his defense team were not allowed to introduce evidence related to his autism diagnosis during his trial because of Stamper. And that gentleman's name is Matthew Rushin. In addition to the Rushin case, as I mentioned, both Jen and Jeff are strongly committed to criminal justice reform. The Stamper decision, of course, impacts everyone living with mental illness in Virginia, but it's really important to acknowledge out loud that it has a disproportionate impact on Black and Brown Virginians. What Stamper did, the unintended consequence of Stamper, was that it created unequal access to justice. So wealthy, privileged defendants in Virginia with serious mental illness, who are almost exclusively white, they were able to have their mental status considered pre-trial because of the work of their aggressive and sophisticated privately retained lawyers. Poor defendants with serious mental illness, who in Virginia are almost exclusively Black and Brown, have to rely on overworked and underfunded public defenders who simply are not able to provide the same level of representation as is retained counsel. So Jeff and Jen, both being kind of heartsick over what happened with in the Matthew Rushin case, and both having a really strong commitment to criminal justice reform and racial equity within the criminal justice system, as well as the context of now having a General Assembly that, because of our flip in 2020, was better able to pass criminal justice reform, decided to take on this terrible decision. So what you're seeing now in front of you is actually the language from, so SB 1315, that stands for Senate Bill 1315. That's what Jen introduced. And then the companion bill in the House 2047 is what Jeff introduced. And what you'll see here is essentially this says that evidence pertaining to the defendant's mental condition at the time of the alleged offense is relevant. And that language was incredibly important because what the Stamper decision said was that it was by definition not relevant. And it will be admitted into trial if it can show that the defendant did not have the intent required for the offense charged. And then down below, it also says that in order to access this new rule of evidence, and I want to be incredibly clear for the attorneys on this call, this is a rule of evidence. It is not an affirmative defense. We already have NGRI as an affirmative defense in Virginia. This is a new rule of evidence. Defendants may access this rule of evidence if they have a mental illness or a developmental or intellectual disability, or are diagnosed on the autism spectrum. So this is actually the language that we needed in order to successfully nullify the Stamper decision. Oh my goodness. So what, why this bill almost died so many times, is, it was a wild ride is really all I can say. And I'll send a bunch of supplementary material to Mary Lou, and she can distribute it to you, or if you have a website, post it on your website so you can watch these committee and subcommittee meetings by yourself if you want to. But why this bill almost died, by far the biggest reason was prejudice and discrimination against people with serious mental illness. So what happened when Jen and Jeff introduced this legislation, there was unanimous consensus in both the House of Delegates and the Virginia Senate that Stamper needed to be nullified for people with intellectual and developmental disabilities and for people with autism. There was no question. There was absolutely no debate whatsoever that it didn't matter if you were center of the road, if you were far left, if you were far right, everyone agreed that it was not okay for people with intellectual disability or developmental disability or autism to not be able to talk about their diagnosis during trial. It's still hard for me to talk about what I had to hear. Where there was strong opposition and dissent was the inclusion of mental illness in this rule of evidence. And it was incredibly clear, listening to some of the things that our delegates and senators said, that this opposition was rooted in nothing but the most abject prejudice and discrimination against people with serious mental illness. Such strong prejudice and discrimination that I wish I could unhear some of the things that I heard people who claim to be compassionate, liberal, forward-thinking people say, and that I can never, and now I have to look at them and know that they said some really awful things. As a result of this prejudice and discrimination, the consideration of mental illness was actually stricken from the bill. We went into conference the night before the last House and Senate vote with the House version of the bill. So Jeff's version had mental illness removed because of this prejudice and discrimination. It had managed to be retained in the Senate version, but it could not move forward if we didn't have, in order to finally be voted on, the versions of the bill had to be identical, and that's why we had to go to conference. Part of the challenge of why mental illness had been removed from the House version was because people were really concerned about how you define mental illness. And the original version had defined it according to the DSM, and that was not acceptable to some members of our General Assembly who felt that that meant that pedophiles, for example, that was one of the examples that we heard so often. This means that we're going to be pedophiles are going to be fully acquitted and walking free on our streets, which isn't what this means at all. This is not if you go back and look at the actual text, like, it isn't, if you have a diagnosis, you are therefore acquitted. It is, if you have a diagnosis, and as a result of that diagnosis, you cannot form intent. And so clearly, whether or not someone is a pedophile, that has nothing to do with their ability to inform intent. So, I mean, it was a red herring that was thrown in as a way to keep mental illness out of the bill. And because there was so much rancor about that in the original version, we actually submitted a substitute which defined mental illness as a disorder of thought, mood, perception, or orientation that significantly impairs judgment or capacity to recognize reality. And people liked this version better. Of course, what's interesting to me is that there are disorders of thought, mood, perception, or orientation that aren't mental illnesses. Dementia, traumatic brain injury. So it was really interesting to watch these lawmakers. They were trying so hard to be as narrow as possible, and then inadvertently they made it broader than I think they even meant to. And that was just a fascinating thing to kind of watch unfold. In addition, in order to get this bill out of conference with the consideration for mental illness intact, we had to agree to adding a clause that would allow for the possibility of an immediate 72-hour commitment upon acquittal. So in Virginia, and I know that all states do this differently, but in Virginia, we have a system of involuntary civil commitment, and that has two parts. The first part is called an emergency custody order, and that is an 8-hour period during which the person is being assessed. And then after that assessment, if they are assessed and found to meet criteria for involuntary civil commitment, they are then subject to what's called a temporary detention order, a TDO, that lasts for 72 hours. And so that's a 72-hour commitment where they're receiving treatment in an inpatient setting. And in order to get this bill with the consideration for mental illness included, we had to agree to allow the criminal court judge to have the ability to order a defendant with mental illness to be immediately taken into custody for a TDO in the event that they were fully acquitted. So essentially what this would mean is if a defendant with mental illness used this rule of evidence, this proposed rule of evidence, and as a result of using this proposed rule of evidence, he or she was acquitted of all charges. So not convicted of a lesser included offense, but was actually acquitted of all charges. If the judge wanted to, the criminal court judge could immediately order the person to serve a 72-hour TDO without first needing that 8-hour clinical assessment. So this was essentially going to be deprivation of liberty potential deprivation of liberty for up to 3 days with no clinical assessment done by anyone. I mean, perhaps a clinical assessment done like at the time of the arrest, which could have been 6 or 12 months ago. But there was so much prejudice and discrimination and so much fear mongering about, if we allow this rule of evidence for people with mental illness, we are going to have dangerous, crazy people running our street, that we had to agree to allow this to be included, or we were not going to get out of conference with the consideration of mental illness still in this bill. So that is the version that passed the House and the Senate. So the version that passed the House and the Senate did extend this rule of evidence to people with intellectual disability, developmental disability, autism, mental illness as defined by disorder of thought, mood, perception, or orientation that significantly impairs judgment or capacity to recognize reality, but that also allowed for this 72-hour commitment with no necessary clinical basis. And that is the bill that went to the governor's desk. And I am not a fan of our governor, but I will say this. Our governor rejected that version. And what he said was, this is an important piece of legislation. And this idea that we are going to be creating a system in which people are deprived of their liberty for up to civilly deprived of their liberty for up to 3 days without a clinical assessment is unacceptable. And so he amended the bill to say that should a defendant with mental illness be fully acquitted as a result of this new rule of evidence, that the judge could order an emergency custody order. So this means the judge could order the person to be evaluated to see whether or not a TDO was clinically appropriate, but that evaluation still has to happen. So I'm very grateful, and that is that bill, that version of this bill was then sent back to the General Assembly, and they endorsed it. So effective July 1st of this year, we will never again see a client not be able to introduce all relevant evidence on their behalf in trial. And we will never again see a client accept an unfavorable plea deal because they know that they couldn't fully defend themselves in court. And I think that this will probably be the greatest victory. It's certainly the greatest victory of my professional career to date. And I have a really hard time imagining a bigger win, to be honest with you. So I've just about maxed out the time that Mary Lou gave me, but there's one last thing. This is kind of my final slide, and I'll stop my screen share now. What I will say is lessons learned. If you're in a state and you are interested in creating a similar rule of evidence, is define mental illness very carefully. That would be my first lesson to you. The second thing I would tell you is be sure to partner with your state's intellectual and developmental disabilities advocates. There is no doubt in my mind that we would not have been, that the only reason this bill was successful was because it was tied to people with intellectual and developmental disabilities. A standalone bill extending this rule of evidence to people with mental illness would never have passed in Virginia. So choose your allies. The third thing I would say is do not assume that all criminal justice system reformers will be your allies. Some of the people that said some of the most vile things were people that we thought were our allies prior to this fight. And then the other thing that I would say is, for us, what ultimately turned the boat around, how we ultimately got mental illness back in the bill. Well, what I'll say, I think some things happen behind the scenes that I will never know about, and that's just fine. But what I also know is that our team wrote a very strongly worded opinion about the equal protection implications of passing this rule of evidence for people with intellectual and developmental disabilities, but intentionally excluding it for people with mental illness. So the Constitution is your friend. And the Equal Protection Clause, I think, was the thing that ultimately saved the day. And I will also say that without the amazing leadership and championship of Senator McClellan and Delegate Bourne, we would not have been successful. So they're not just a senator and a delegate. They are highly, highly, highly respected leaders with long track records in Virginia. So their influence was incredibly essential. It wasn't enough, though. It absolutely was not enough. So I think those are kind of our lessons learned. And that's really that's the story. That's it. That's how we burned the Stamper decision to the ground. I'm thrilled that we did it. I'm heartbroken because the harm done by the Stamper ruling over the last 36 or 37 years is really, really incalculable. And there are people incarcerated today serving very long sentences that, had they had access to this rule of evidence when they were facing their charges, they would not be incarcerated today. So I'm so grateful for this opportunity, and I'm grateful for the being able to model to our 6-year-old that when there's a bad law, you change the damn bad law. But it also came 36 or 37 years too late for a lot of people in Virginia. So with that, I'm gonna be quiet and turn it back over to Mary Lou.
Thank you, Anna. And I did not understand the depth of what you had gone through in this fight. And I know you don't give yourself a lot of credit. You were telling me that you were following the work of the legislators and their behind the scenes, at least at some point. But your passion and your deep understanding of the issues here are just really sort of breathtaking to me. We find that, like you said, 36 years, 40 years, I can't recall offhand now how long our laws have been the same way here. I think you had beat us out. That's right. Your laws had been written this way a little bit longer than ours, but you get used to that, walking that path where it's normal to see people that are arrested for a crime that they committed due to their illness, and for that outcome to be so bad, and that those people just continually end up in prison. As you mentioned, the the lack of felony diversion. It's very similar. There were a lot of similarities as you told your story and to what we have here in Arizona. The system navigation that you do. It was incredible though to see a lot of times we do the work, we do our part, but we don't put all those pieces together. We don't, unless you're a family member, have a loved one that's experiencing this, the impact of it all doesn't hit you. I know when I first started doing this, I thought I must be missing something. It couldn't be true that a person that's sick and did not have criminal intent is going to be sentenced to prison the same as a person who did. And to my shock and dismay, years later, really, that it took me to really understand that really is the case, and that's the way our laws are. So just our hats off to you. We're so proud to have you as our friend here in Arizona. And I know this video is going to be shared. I'll bet you hundreds, if not thousands of times once the word gets out of what has happened there in Virginia. So I know you mentioned that you're going to be sending us some of the resource links, so that'd be great. We had a question early on about the study. Will the link to that study be included that we could send out, the study that you had referenced when you first started?
I will see if I can get permission to share that. Yes.
Okay, great. Yeah, it's very and one of the things that struck me, and our coalition members have heard us talk many times about the topic, but and I struggled for probably a year trying to get a good way to verbalize, just to put it in words, what's happening in our court system. Our police are doing everything right. They're, CIT trained, they're mental health, first aid trained, they're taking people to drop-off centers. We're doing so much right on that front end. But what's happening when we get into our court system that that would be such a block for just basic justice to happen. And so that's why, as you mentioned, I felt just such camaraderie with you, that all people that you see are doing criminal justice reform are not necessarily going to be your good friends. So it's a very technical area, really. And what I so appreciate about you and the way you have been able to reach out into your community and to us here now across the nation, you're reaching out, is the simplicity with which you are able to share, what you were faced with and how you were able to be a part of bringing that change that's going to improve lives for hundreds and I'm sure thousands of people. So it's, I'm not a lawyer. I know you're not a lawyer yet, but I'm going to ask you a question that you might have to be a lawyer to answer. I'm not sure, but
Okay.
One of the questions I had, what struck me, one of the things is that you were mentioning this is not an affirmative defense, but it's a rule of evidence. Now, I thought that when I've been looking at this stuff for a while, I thought rules of evidence had to be created by the courts. Is that completely wrong? That's a rule of evidence created by the legislature?
So that's a good question. I don't know. All I know is that and maybe this is a state by state thing. I don't know. All I know is that the attorneys who were working with us on this kept referring to it as a rule of evidence. And so that was, and I kept asking myself, why is it so, like, why do they keep saying it's a rule of evidence? Like, what else would it be? Like, why do they keep referring to this as a rule of evidence? And that was when I learned about affirmative defenses. And so perhaps they were just saying it that way to differentiate it from an affirmative defense. But that is certainly the terminology that they used.
Okay, yeah, thank you. And yeah, I see another comment here in the chat that might be vary from state to state. And then we had another question. Once this is enacted, will folks have will they have grounds to appeal sentences that had already taken place? That's a good question.
Oh, that's a great question. And so what I'm gonna say is that I don't think I'm gonna be able to find the picture quickly, so I'm not even gonna try. But what I will say is that I think I said, you know, in one of my slides, I'm like, why now? And I gave a bunch of reasons as to why now. And I did reference a young man named Matthew Russian. And he has been incarcerated for the last 10 years. He has very severe autism. And he has been incarcerated for the last 10 years, serving a 50-year sentence for a crime he would not have been convicted of had he had access to this rule of evidence. And his mother has been filing a clemency petition on his behalf, I think, every year since he began his incarceration. And because of this success in the General Assembly, her most recent clemency petition was granted 2 days after this bill passed the legislators. So Matthew has since been released. I have this beautiful picture of him and his mom embracing outside of prison for the first time in 10 years. So we at Partner for Mental Health, we are certainly aware of some of our clients who are serving prison sentences now that we don't think they would be serving were it not for Stamper. And so we actually have started the process of exploring a group clemency process for them. We are also only, you know, one small organization in one small town in Virginia, and this is a statewide issue. So we are looking at how can we spread the news about this and what it might mean for people more broadly. Next month, I'm going to be providing some continuing legal education to the state bar. So part of what this bill did, so this bill nullified Stamper. That was the big thing that this legislation did. But what it also does is it also requires criminal defense attorneys to get two hours of CLE on an annual basis regarding the special considerations for adequately representing neurodiverse clients. And so I will be giving kind of I'll be giving the CLE with an attorney who's going to be talking about the legal aspects, and I'll be talking about the clinical aspects. And one of the things I'm going to say is, and you guys are defense attorneys, you've defended people who are now in jail and who shouldn't be there. So please help us spread the word. Because we believe that they now have a stronger basis for clemency in Virginia, assuming, this is a big, big assumption, assuming they never pled guilty. In Virginia, if you pled guilty, the likelihood that you will ever to anything, even if it's a lesser included, like even if you got a nice plea deal and you pled guilty to something that was not the big thing you were initially charged with, you will probably never get clemency. So that's that'll be our next battle. That's our next battle. That's our next battle.
Thank you for that, Anna. And wow. So we will be following closely as this new rule of evidence is incorporated into practice in Virginia. Our goal, as is yours, is to see people receive treatment so that our communities will be safer and not continue that repeating cycle of incarceration and then folks being released again. And our Department of Corrections, God love them, having to be the psychiatric providers for people with serious mental illness. They're not set up to do that. And people going into our state prisons, coming back sicker than when they went in. Oftentimes going into jail as well, coming back sicker. Now our jails and our county sheriff's offices are doing a good job to try to keep people well, get them treatment while they're in and get them linked up with services. And that was one of the reasons why I was talking about the nomination that I'd made at the CIT International Conference here. But it's even with so many stakeholders that are involved in this doing things right. The landing place for folks is in the courts. And you know, why are we always, my question has always been, why are we pressuring so much to law enforcement who's making split-second decisions every day to keep people safe? And as for whatever practices that our laws require our courts follow, we don't even question. So you know, it's like you said, I loved what you said, and you always say everything so well and simply. If you have a bad law, change it. So you've given us hope that that can happen, and you've certainly I've certainly learned a lot, and I hope everyone else has from the presentation.
Can you guys, I'm going to interrupt you. Mary Lou,
Oh.
Can everyone see my screen? I don't think I can make it. I can try to make it bigger.
Okay, we can see it. There,
Can you,
yeah.
that
Yes.
is Matthew and his mom about an hour after he was released from prison as a result of this development.
Fabulous.
It's
Fabulous.
it just like, this is why we do what we do. So.
Fabulous. Well, thank you, Anna. And we're about to the end of the meeting. I want to again thank each and every one of you for being here today. I hope you learned a lot. You'll be able to see this entire presentation on the David's Hope YouTube channel going forward. It should be up within a day or so. And Anna, I know you have also shared your contact information. I included that in the original mailing. So thank you for doing that. And we will go ahead and close the meeting. I'm not seeing other just comments. People were so touched emotionally by your presentation, Anna, and are thanking you for your work.
Well, thank you, Mary Lou. Thank you for this opportunity to talk a little bit about what we had the opportunity to really be involved in. Yeah, my contact information is in the kind of the initial thing that you sent out, Mary Lou. My email address is Anna, that's ANNA @partnerformentalhealth.org. Partner, and then for is the word for, FOR, all spelled out, partnerformentalhealth.org. Please reach out if you have any like follow-up questions or things you want to touch base on. If any one of you is aware of another state that has their own stamper decision that needs to be burnt to the ground, please let me know about it, because we're certainly willing to share our experience as you know, as widely as would be helpful. I will say at Partner for Mental Health, we have this big whiteboard in our kind of like multi-purpose room, and we have a list on it that our whole team can write on. And we have like, and it says like organizational goals, and we have a column for short-term org goals, mid-range org goals, and long-range org goals. And I encourage all of us to, like, as something comes up, like throw it up there. So we've got short, mid, long-term goals, but then we also have this like area where it's like in our wildest dreams, right? Which like this will never happen, but if we had a magic wand, like wouldn't it be great? And I will tell you that 2 years ago, we wrote overturn stamper on in our wildest dreams column. And we never and it was like, and we laughed about it. Like, ha ha ha, that will never happen, right? And so I guess that just speaks to, and we talk about this with our clients all the time, right? Like, no one can ever tell you what tomorrow might bring. And so like, we always have to hold hope. Like we have to hold hope when we're doing like big picture statewide level advocacy. And we also need to hold hope when we're working with people that we have seen be arrested 84 times in 14 months, or, relapse 10 times into alcoholism in a year, because no one knows what is possible. And so we have to hold hope that tomorrow can be better.
Fabulous. Well, I'm glad you added that. And Arizona has our stamper is our Mott's ruling, like Mott's applesauce. And it's a real nightmare. And we've had it almost as long as you've had that stamper, but so we will hold on to hope. So thank you, Anna. Thanks for being with us, and thanks to all. We'll see you all next month, second Wednesday, as always. And God bless everyone. Stay safe and keep up the good fight. Thank you. Bye-bye.